to render judgment based on law and evidence without regard to the circumstances and personalities of the parties involved, however controversial they may be. She is to dispense justice without fear or favor. We here all took an oath to do impartial justice according to the Constitution and the laws of the Philippines. And like Lady Justice, we are bound to do so without fear or favor. An impeachment trial is sui generis. But be that as it may, the Bill of Rights stands supreme over all the powers of government, including the power to impeach. And nowhere is this precept more apposite than in this case, where the government has mustered all the resources at its disposal, not only to secure evidence against the Chief Justice, but further to ensure his conviction. The crucial issues that have piqued the interest of the senator judges, as well as the public, were outside the original ambit of the impeachment complaint and have been brought forth only after its filing. Evidence on some of these issues came from questionable sources, beginning with the unidentified little lady to documents anonymously left on gates and in mailboxes. At the expense of the sub judice rule, evidence had been presented to the public on several occasions, even before they were formally offered before this court. Worse, information was grossly exaggerated with the apparent intention to predispose the public mind against the Chief Justice. Notable examples would be the Land Registration Authority report with a discredited list of 45 properties and the unauthenticated AMLAC report claiming that the Chief Justice allegedly owned $10 million. Still, the Chief Justice sufficiently addressed the accusations against him with regard to the filing of his SALEN and the disclosure of his real properties and pesos deposits. Relative to his dollar deposits, the Chief Justice believed that he was under no legal duty to declare these deposits pursuant to RA 6426, which affords absolute confidentiality to all foreign currency depositors. This interpretation of the law is now being publicly criticized as flawed. However, it is known to all of us that quite a number of public officials construe RA 6426 vis-a-vis RA 6713 in exactly the same manner. In view of the ambiguous situation created by the concurrent application of the 1987 Constitution, the SALEN law, and the FCDU law, and absent a determinative judicial pronouncement that resolves the contrary positions on this legal issue, the Chief Justice must be presumed to have acted in good faith. Indeed, it has been held that not all omissions and misdeclarations in the SALEN amount to dishonesty. The framers of the Constitution intended culpable violation of the Constitution to mean a willful and intentional violation of the Constitution. Betrayal of public trust, on the other hand, was meant to be a catch-all phrase to encompass all acts violative of the oath of office or which render the officer unfit to continue in service. Both grounds, however, were contemplated to exclude unintentional or involuntary violations, errors made in good faith, and honest mistakes in judgment. Granting, therefore, that the Chief Justice violated the SALEN law, this certainly does not rise to the level of an impeachable offense. We may be faulted for erring on the side of conservatism, but what we are doing is nothing less than redefining the relationship between branches of government. And when such great affairs of state are uncertain, the resulting instability puts every Filipino's future in limbo. This is an important, delicate, momentous event, and because of that, we should tread very lightly. We must be very, very careful and very, very fair in making this decision, because what we do today will reverberate throughout our social and political history, affecting generations beyond ours. When the furor has died down and this political storm has subsided, I know that, like Lady Justice, we shall find solace in the fact that this decision, though maybe not popular, was fair, impartial, and just. On the arguments presented and on the ground that the presumption of innocence has not been overcome, I vote to acquit the Chief Justice of the Supreme Court.
Honorable Senator Judge Osmeña.
Mr. President, esteemed colleagues, honorable members of the House of Representatives, distinguished members of both the prosecution and defense panels, my countrymen. In arriving at our decision today, we narrowed our concerns into four. One, did Chief Justice Renato Corona violate the Constitution? Two, did he do it knowingly and willingly? Three, was the violation of such gravity as to warrant his impeachment? And four, has Justice Corona betrayed the public trust? Ironically, the answers to the first two questions were supplied by the defendant himself. When Justice Corona admitted he had not disclosed in his yearly statement of assets, liabilities, and net worth over 180 million pesos in cash or near cash. While not in consonance with the SAL law, Justice Corona gave as his excuse the FCDU law. Yet nowhere in that FCDU law is the depositor not allowed to disclose his own deposits. All the FCDU law prohibits is that the depository banks and third parties are not allowed to disclose the account and the amount of deposits. Searching for the answer to the third question took a little longer. Is the violation of the SALN law of such gravity as to merit impeachment? Not surprisingly, the answers were again supplied by Justice Corona and the High Court. Numerous decisions on cases involving SAN law violations have been handed down by the Supreme Court. Among others, Rabe versus Flores, Concerned Taxpayer versus Doblada, Carabeo versus Court of Appeals, Office of the Court Administrator versus Usman, Flores versus Montemayor, and several others. In Rabe versus Flores, for example, the Supreme Court ruled that a simple, humble court interpreter in Davao del Norte in Mindanao had to be dismissed from service because she had failed to disclose in her statement of assets and liabilities and net worth that she rented a market stall in the Panabo market. The High Court further ruled that Ms. Flores was perpetually disqualified from holding office. I went a bit further and posed a hypothetical question of myself. If the court had been supplied with a bank passbook belonging to Mrs. Flores, which showed a deposit of $10,000, which had not been reported in her SALN, would the court's ruling have been the same? Dismissal and perpetual disqualification from office? My plain, ordinary, legally untrained, but reasonable mind tells me yes, the Supreme Court would have ruled similarly. If these public officers had been dismissed from office for failing to declare far less remarkable, far less valuable assets in their SALNs, despite and regardless of their excuses, then there is more reason to apply the law when the assets in question amount to over 180 million pesos. We should not penalize the poor man for stealing a bicycle, but rule that the rich man must first steal a Mercedes before he is subjected to a similar penalty. My fourth and last question was, did Justice Corona betray the public trust? Again, ironically, the answer was supplied by Justice Corona and the Supreme Court. For contained in the new Code of Judicial Conduct for the Philippine Judiciary, under Canon 2, which covers integrity, are two sections. One, judges shall ensure that not only is their conduct above reproach, but that it is perceived to be so in the view of a reasonable observer. Two, the behavior and conduct of judges must reaffirm the people's faith in the integrity of the judiciary. Justice must not merely be done, but must also be seen to be done. Mr. President, we all must face the Miss Floreses of our country, whether in Mindanao, the Visayas, or Luzon. We must be able to tell them that justice is, to the best of our ability, being applied equally to the rich and to the poor, to the powerful and to the powerless. The Senate Impeachment Court must restore the people's faith in the judicial system. The Senate must bring about a higher level of moral standard in governance. I therefore find for the people guilty on Article 2.
Honorable Senator Judge Pangilinan.
Kagalang-galang ng mga kasamahan sa Impeachment Court. Mga kababayan, magandang hapon po sa kanilang lahat. Hindi dineklara ni Ginoong Corona ang daang milyong piso at dolyar na mga account. Hindi niya idineklara taon-taon ang mga milyong-milyong pisong pag-aari ng mga condo units. Ang hindi pagdeklara ng makatotohanang salin taon-taon sa loob ng halos isang dekada ay dishonesty at isang culpable violation of the Constitution. Ano po ang ebidensya? Nariyan ang salaysay ng PS Bank President, ng Ombudsman, at ni Ginoong Corona mismo. 22 million ang sinabi niya sa salin niya, ngunit halos 200 million cash ang hawak niya. Ito ba ay minor na kakulangan lamang? Dapat bang daang bilyon ang hindi idineklara para maging mabigat ang kaso? At kung sa malinis na paraan nakuha ang mga ito, ano ang masama na ideklara niya lahat? Dahil wala naman siyang itinatago. Di dapat ikaila kung walang tinatagong masama. Base sa ebidensya, maliwanag na nagkaroon ng sistematikong pagtatago ng ari-arian, sistematikong pagtatakip sa tunay na halaga ng mga ito. It pains me as a lawyer and an officer of the court to say that clearly the Chief Justice displayed a disturbing pattern of dishonesty, willful concealment, and evasion, and a blatant and wanton disregard of the provisions of the Constitution on the statements of assets, liabilities, and net worth. Sa paglilitis na ito, nakita rin natin ang pagkatao ni Chief Justice. Siya ba ay dapat pa nating pagkatiwalaan? Kung hindi po natin i-convict si Ginoong Corona, sabi po ni Speaker Belmonte, 6 na taon pa siyang uupo bilang Chief Justice. Kung kaya niyang ipagkait sa mismo niyang kamag-anakan ang kanilang ari-arian sa Basagidote, gayong daang milyong na pala ang kanyang cash, siya ba ay dapat pagkatiwalaan sa loob pa ng 6 na taon? Kung kaya niyang ipakita ang kawalan ng respeto sa 23 senador nung siya ay nagtangkang mag-walk out, na sa aking paniwala ay napigil lamang dahil sa mabilis na kilos ng ating mahal na Senate President. Ginawa niya ito sa harap mismo ng lahat ng media at buong bansa. Paano kaya ang pagtrato niya sa maliliit nating mga kababayan na hindi mga senador na dumudulog sa kanyang tanggapan? Siya ba ay mapagkakatiwalaan pa ba na rumispeto sa maliliit nating mga kababayan sa loob ng 6 na taon? Dapat po siya managot dahil siya po ay nagkasala. Tulad na lamang ng isang court interpreter sa Davao na sinibak mismo ng Korte Suprema dahil hindi niya iniligay sa kanyang salin ang pag-aari niyang market stall sa palengke. Tama ba na ang pagsisinungaling ng maliliit at mahihirap ay parusahan, habang ang pagsisinungaling ng makapangyarihan ay absuelto? Ang pagsisinungaling ba ay impeachable offense? Si Chief Justice na mismo ang nagsabi sa kanyang talumpati sa harap ng Manila Overseas Press Club noong June 24, 2010, kung ano ang nararapat sa mga huwes na hindi tapat sa tungkulin. Sabi po ni Chief Justice, and I quote, "I believe that a member of the judiciary who is found guilty of dishonesty should not only be dismissed from the service, he should also be disbarred. No ifs or buts." Siya na po ang nagsabi na kapag ang isang huwes ay nagsisinungaling, hindi lang ito dapat sibakin sa pwesto, dapat pa ho ito madisbar bilang abogado. Sa kanyang mga labi na mismo nanggaling na nararapat siyang makonvict at masibak sa pwesto. The vote to convict is a vote to defeat abuses and excesses in government. Ang boto ng conviction ay boto upang wakasin na ang pang-aabuso at pamamalabis ng mga opisyal ng ating bansa. We all want a better, more progressive nation. We all want our nation to reach developed nation status in our lifetimes. And yes, for our children. But critical to a modern state is an effective system of justice that has the trust and faith and confidence of our people. We all want to see the end of abuses in governance. We have heard of exposés after exposés of abuses in government. We have witnessed lawlessness, criminality, corruption, and disrespect for the rule of law. Respect for the rule of law will only be realized if punishment of the guilty is swift and in a fair trial. Unless we punish more and punish swiftly, lawlessness, abuse, and disregard of our laws will not be defeated. Those who wish to abuse their offices will continue to be emboldened to commit their nefarious activities. Only when we punish the guilty and punish them swiftly in a fair trial will respect for the rule of law be restored. No less than the Chief Justice has been accused of culpable violation of the Constitution. To convict him is to uphold the rule of law and will send the signal to the entire nation that the rule of law should be respected and it should strike fear in the hearts of all those who wish to violate our laws and disrespect our Constitution. For this reason, I find the Chief Justice guilty.
Honorable Senator Judge Pimentel.
Magandang hapon po sa inyong lahat. Maayong hapon kaninyong tanan. Impeachment is a constitutional administrative proceeding. When there is sufficient credible evidence to prove a constitutionally recognized ground for impeachment, then the impeached high government official must be removed from office. There is evidence on record which shows that Respondent Corona did not declare in his SAL-ends for certain years real properties worth millions of pesos. There is also evidence on record as well as admissions that millions of pesos and millions of dollars were also not declared in the respondent's SAL-ends. The arguments of the respondent do not persuade this Senator Judge. Number one, the ownership of real property is transferred upon delivery of the real property sold. When the contract of sale of real property is embodied in a public instrument, the execution of the said instrument is equivalent to delivery of the thing sold. Number two, there is no law exempting commingled funds from disclosure in the SAL-N. Minarapat sana ng punong maestrado na iwasan ang ganitong mga alanganing transaksiyong pinansyal. Hindi na nga iniwasan, ginagamit pa ang kasangkapan upang hindi tumupad sa kanyang tungkuling ilahad ang tunay niyang yaman. Number three, The duty of a public officer or employee to submit under oath a declaration of assets, liabilities, and net worth is mandated by the Constitution. In case of conflict, the Constitution prevails over RA 6426. Number 4, the SALN is required by RA 6713, a 1989 law. The respondent relies on RA 6426, a 1974 law. In case of conflict, the later law prevails over the earlier law because the later law is the latest expression of the legislative will. Number 5, RA 6713 emphasizes the obligation of the public official and employee to file his SALN, as well as the right of the public to know their assets, liabilities, and net worth. The 1974 law, RA 6426, cannot be interpreted in such a way that it would nullify the main purpose of the Code of Conduct as a tool against graft and corruption. Hindi layunin ng RA 6426 ang magsilbing kanlungan sa mga tiwali sa gobyerno. An earlier law cannot be interpreted to nullify the purposes of a later law. The respondent relies too much on the phrase, and I quote, of an absolutely confidential nature. This phrase is practically useless as the Secrecy of Bank Deposits Act itself provides 4 exceptions. Jurisprudence and other laws add 6 more exceptions. The Foreign Currency Deposit Act, the FCDA itself provides 1 exception, and jurisprudence and other laws provide for a further 2 more exceptions. How can something be of an absolutely confidential nature when there are so many exceptions to the rule of confidentiality? The 1974 Foreign Currency Deposit Act and the 1989 SALN law do not have to exclude each other. They can be harmonized. This senator judge respectfully submits that the 2 laws could be harmonized as follows. Foreign currency deposit accounts continue to be protected from idle inquiry, but the amounts of these deposits must be declared as assets in the SALN, converted to Philippine peso, without need of disclosing details like the existence of the foreign currency accounts, the name of the bank, and account numbers. Furthermore, RA 6713, in requiring that the SALN shall contain information on all other assets, does not distinguish between peso and foreign currencies. When the law does not distinguish, neither should we distinguish. The respondent has consistently misinterpreted all the laws as releasing him from his constitutional duty to disclose his entire assets in his SALN. The respondent never corrected his SALNs to reflect his true net worth. These facts have convinced the senator judge of the respondent's intent to avoid his constitutional duty to disclose his true net worth. Simple lang, kung ayaw mong ilahad ang tunay mong yaman, huwag kang pumasok sa gobyerno. Under RA 6713, any violation is sufficient cause for removal or dismissal of an ordinary public employee. Ang patakarang pinapatupad para sa pangkaraniwang empleyado ng gobyerno ay dapat ding ipatupad sa punong maestrado, sapagkat tayong lahat ay pantay-pantay sa ilalim ng batas. Ang batas para kay Juan ay batas din para kay Renato. Therefore, the senator judge finds the respondent, Chief Justice Renato C. Corona, guilty of culpable violation of the Constitution and betrayal of public trust under Article 2 of the Articles of Impeachment.
Honorable Senator Judge Recto.
Just a minute. Let's have a recess for a few minutes.
Pansamantala pong